Ipob cautions Justice Omotosho against halting Nnamdi Kanu's trial based on Kenyan court ruling. Good day, my dear listeners. Thanks for joining. Yet on today's occasion, I bring to you another interesting news as the indigenous people of Biafra, Ipob, cautions Justice Omotosho against halting Nnamdi Kanu's trial based on Kenyan court ruling. Moving on to the full details, kindly please ensure you like, subscribe to this channel and share. The indigenous people of Biafra, Ipob, has cautioned that the recent judgment by the Kenyan High Court, which ruled the abduction and extraordinary rendition of its leader, Nnamdi Kanu, as illegal and unconstitutional, must not be used as a legal basis to halt his ongoing trial in Nigeria. In a statement signed by Barrister Onyedikachi Ifedi on behalf of the Ipob Directorate of Legal Affairs, the group acknowledged the judgment of the Kenyan court but emphasized that Justice James Omotosho of the Federal High Court in Abuja is constitutionally barred from acting contrary to the Supreme Court of Nigeria's ruling on the matter. While we acknowledged and commend the Kenyan judiciary for upholding the rule of law and condemning the illegal actions, that led to our leaders' abduction and torture, we find it necessary to clarify a fundamental constitutional limitation under Nigerian legal system. The statement read: citing section 2871 of the 1999 Constitution, Ipob stressed that all subordinate courts are required to comply with the decisions of the Supreme Court. The decisions of the Supreme Court shall be enforced in any part of the Federation by all authorities and persons, and by courts with subordinate jurisdiction to that of the Supreme Court. Ipob quoted the Constitution as stating. The group noted that the Supreme Court had remitted the matter to the lower court for trial, despite acknowledging that Kanu was subjected to what it termed a criminal abduction and unlawful rendition. According to Ipob, Justice Omotosho is duty-bound to abide by the judgment regardless of its controversy or flaws. No trial court, regardless of circumstance, is permitted to override, ignore, or set aside a Supreme Court judgment, Ipob said. His Lordship, Justice James Omotosho, may take judicial notice of errors, and there were significant errors in the lead judgment, but it cannot act upon them unless and until the Apex Court overrules itself. The group referenced Rosek vs. ACB Limited, 1993, 8 NWLR Part 312-382, which held that lower court must obey Supreme Court pronouncement, no matter how manifestly bad or perverse they may appear. Ipob accused the Supreme Court of ignoring critical safeguards that should have voided Kanu's trial. These include Section 15 of Nigerian's Extradition Act, which prohibits prosecution for offences outside the terms of extradition. The precedent in Gabriel Izeze vs. the State 2004 8 NWLR Part 875433, which mandate the consent of the surrendering state, Kenyan in this case, for any new charges. Violations of the African Charter on Human and People's Rights, especially Articles 5, 6 and 7 prohibiting torture, unlawful detention and denial of fair trial. Breaches of the International Covenant on Civil and Political Rights ICCPR, to which Nigeria is a party, including Articles 7, 9, 13 and 14. Why the Supreme Court ignored these foundational principles is a mystery to many. Ipob said, adding that strong legal arguments exist, that the judgment was given per incuriam without reference to relevant legal principles or statutes. Nonetheless, Ipob considered that only the Supreme Court itself can reverse or overrule such a decision, citing Adisa vs. Onyiwola 2010 NWLR Part 674116. The group argued that while the ruling of the Kenyan High Court was significant, it carries no binding authority in the Nigerian court unless domesticated through treaty ratification under Section 12 of the Constitution. My dear listeners, now I've come to the end of our today's news. Please do drop by the comment section and let us know what your view is all about. Thank you for listening.